Good
morning, everybody.
Good morning, Aloj.
Good morning, my lord.
Good morning.
Item number 1, of 2018.
My lord, may my lord, may I seek your lordship's hand indulgence?
Let these petitions be placed before a bench of which one of us, within bracket, Deepak Roshan J, is not a member. Here.
Item number 3, LP number 310 of 2019. Mr. Apan Banerjee for the applicant, Mr. Suresh Kumar, Mr. Sugatru Srivastava.
My lord, in case I am appearing on behalf of appellant, your lordship. As per the earlier, your lordship has awaiting for the report, your lordship.
Deepak Dubey is submitting something.
Deepak Dubey, आवाज आ रही है आपको?
My lord, am I audible, my lord?
यहाँ पे सामने नहीं जा रहा है।
यहाँ पे कुछ दिक्कत है।
Am I audible, my lord?
Are you absolutely going to hear us? Hey, Mr. Prabhat.
My lord, आपकी आवाज
Yes,
तो आ
your
रही है।
lordship, आवाज आ रही है.
Yes, my lord.
Are we audible?
Yes, my lord. My lord is very much audible to us.
Sign language. We are not able to understand our query.
क्या चल रहा है mentioning it?
ये ढीला होगा कुछ शायद।
आवाज आ रही हो जो?
इसमें तो ऑन ब्लू लाइट जल रहा है।
Lordship.
Yes, yes, your lordship.
Okay. So first two cases have been assigned to another bench because brother wanted. We had already passed the order.
Okay. That's okay, my lord.
Milits, I think the earlier it was better. Well, it's so far as the voice recognition is concerned. Milots are not very clear in what Milots are saying. I think the mic is fixed elsewhere.
ये connected नहीं है। We are not able to figure out whether from where our audio is actually transmitting.
That is what, and I think every time Milots is speaking, Milots is turning to the right side, I believe.
No, actually, because the screen has been put this side, so I'm looking at you. The day before yesterday, it was physical, so councils were in front. We did not look at the other side.
Okay.
On the screen. there is a different small camera with
But the
which you
lordships are not visible. Only some part of the lordship is.
ठीक करिए.
लगता है कैमरा वेब कैमरा को सामने रखा गया है, स्क्रीन राइट साइड में रखा हुआ है माय लॉर्ड का, इसीलिए ऐसा हो रहा है.
हाँ, but that's not the difficulty. We can look at the screen like this and talk to you or have a argument, hear your arguments. But whether our voice is going properly, seamlessly or not, that we want to know.
आवाज तो साफ आ रहा है मुझे.
Voice is clear, lordship.
Okay. Then we can continue because the screen has been placed on the right side. Day before yesterday it was physical court and we were seeing the councils in our front.
Yes, sir.
Maybe. Third case call करिए.
Item 3, LP number 313.
Lord, in this case, I am appearing on behalf of appellant, Your Lordship. As per the last order, Your Lordship, awaiting service report, Your Lordship.
No, the respondent has died. As per the service report. So you'll have to take steps for substitution.
My Lord.
Respondent number 1, writ petitioner has died.
My Lord.
Then counsel for the appellant state, Mr. Deepak Kumar Dubey, raised for his and is allowed 3 weeks time to take steps for substitution of the deceased respondent number 1 as has been stated in the service report. As stated in the service report. So it is indicated that the respondent number 1 has died on 28th November 2020. So you take steps.
My Lord, my Lord. My Lord, one prayer, Your Lordship. In place of name of Mr. Atanu Banerjee, may the name of Mr. Sachin Kumar appear, Your Lordship, in the cause title, Your Lordship, cause list, Your Lordship.
Let the name of AG2 appear in the cause list in place of the erstwhile counsel Mr. Atanu Banerjee and Mosmi Chatterjee.
In my Lord. Oblige, Your Lordship.
For admission, item code WEG number 136 of 2017, along with item number 5. With a view for the petitioner. Without evaluating the subject amount of
So, who is appearing? Mr. Pudar?
Yes, my lord, I am appearing in this case, my lord.
Why can't the petitioner prefer an appeal against the
Yes, my
revised assessment order?
lord, despite the alternative remedy available under section 79 and revision under section 84, this writ application is maintainable under the facts and circumstances because the reassessment order which has been passed is wholly without jurisdiction, and further there has been violation of natural justice and equity. Therefore, my lord, if my lord will allow me to put certain facts before your lordship, my lord, I think my lord would like to entertain this application, my lord. My lord, by Annexure 3,
As per your case, the original assessment which the matter was remanded to the assessing authority.
for passing
But-
fresh assessment order.
But as per the respondents, the reassessment order has been passed because interest and penalty could not be levied in the earlier assessment order by mistake.
Now, my lord may kindly consider that certain facts I may be allowed to put. By Annexure 3, my lord, original assessment order was passed, against which I preferred revision before the commissioner, and during the pendency of that revision application, audit objection Annexure 7 was raised, and the AO, when it was shown to AO did not agree, and thereafter on the basis of audit objection, when he received, he issued notice for reassessment under section 42(3). And in the meantime, that revision application was allowed by the commissioner, and with a direction to pass fresh assessment order and allow me to file the form JVAT 404 for claiming ITC, my lord. And accordingly, I appeared on being noticed. I was given notice for passing fresh assessment order as directed by the commissioner, and I appeared and I was heard on for the purpose of passing a fresh assessment order. And on the basis of that audit objection, mechanically notice was issued under section 42(3), and I filed an objection which was brushed aside. And instead of passing a fresh assessment order where my forms could have been considered and my ITC claim would have been allowed, and if it had been allowed, the question of imposition of interest and penalty would not have arisen. But instead of passing fresh assessment order, he passed reassessment order on the basis of 42(3), my lord. My lord, may kindly allow me to place the entire order sheet annexer 5 at page 62, my lord. Typed copy is also there, my lord.
The appellate forum.
Yes, my lord.
These aspects these grounds can be looked into by the appellate forum also.
My lord, it is wholly without jurisdiction because of the reason that the commissioner's direction was not complied with. The audit objection which was not existing because of the reason that the audit objection which was raised against the original assessment order, which was already set aside. Therefore, question of audit does not audit objection, then the order passed is without jurisdiction. That has been held by Honorable Supreme Court in 2017 volume.
Who is appearing for the other side?
Yes, my lord. Larsen Tubro case, my lord, 2017, volume 13, 780. Under these circumstances, the Honorable Supreme Court says that the order passed is wholly without jurisdiction if he has not recorded any satisfaction, my lord. And if my lord will allow me to place the entire order sheet, it is clear that he has mechanically issued the notice without application of mine, my lord. And moreover, when the auditor, before the auditor, he himself did not agree with the objection.
These things, the authority would be in a better position to examine.
Jurisdiction के होना चाहिए, कोई आपको पावर नहीं है इसमें. That is not the case. Even the commissioner has remanded the case, and you have asked right or wrong.
Right.
Exactly.
Examine all those orders, first order, second order, third order. Mr. Pradhan, we are of the view that you better avail the appellate remedy. The appellate authority will
My lord, proceeding or revisional proceeding as provided under section 80 subsection 4 of the JVAT Act, my lord. Because both remedies are available to me.
You can take the plea of pendency of the writ petition also. If there is a delay.
Section 80 subsection 4. And my lord, there has been violation of natural justice and equity before imposition of interest and penalty. Admittedly, no show cause notice was given, my lord. In the counter affidavit, they do not deny this.
Take all those. We will indicate that these are the grounds you are taking up. We will indicate in our order that these grounds you are taking up to challenge the order which the appellate authority is.
Revisional authority, my lord. I will file revision before the commissioner, my lord.
Very well, that's better because the revisional authority had passed the remand order.
Yes, my lord. Therefore, revisional authority के यहाँ हमको भेज दिया गया. Section
The limitation, no order under this section shall be made after 2 years from the date of filing of such appeal. Where is there any limitation in favoring the revision?
No, my lord. No limitation is prescribed.
Okay.
84 में there is no
limitation. This petition, third learning counsel for the senior counsel for the appellant, other side to go behind. This petition has been preferred for the following reliefs. Para 1. A, B, C, D, E, F. Then senior counsel for the appellant submits that the reassessment order dated 14th October 2016, annexure 16 at 12 is illegal and void and in ab initio after the matter was remanded by the revisional authority by order dated 13 July 2016 . Stop. Though petitioner produced the books of account and other documents including form JVAT 404 in original and also original C form for the amounts availed, for availing the amounts, but instead of passing a fresh assessment order under section 35(6) of the JVAT Act 2005 as directed by the commissioner, the Assistant Commissioner of Commercial Taxes, Bokaro Circle, Bokaro has passed a reassessment order under section 42 within bracket 3 of the JVAT Act on the basis of the audit objection which was raised against the original assessment order. Stop. The original assessment order did not survive after remand by the commissioner. Stop. Therefore, there was no question of passing any reassessment order. The reassessment order has not passed under section 42(3) of the Act has not taken into account the form JVAT 40 form produced in original before the assessing officer, as also different statements filed by him through his forwarding letter dated 17th August 2016, annexure 10. Stop. And counsel for the petitioner has taken further grounds that the impugned reassessment order is a mere reproduction of the audit objection which had become non-existent without any fresh application of mind, showing necessity, fresh application of mind on this personal satisfaction of the assessing officer for passing the reassessment order. Stop. The imposition of interest and penalty on the ground of non-production of JVAT 404 is without proper opportunity of hearing as well. Therefore, the petitioner has inter alia taken other grounds as well to assail the impugned order before this court under Article 226 of the Constitution of India. Stop. Learned counsel for the appellant has placed reliance upon the case of Larsen and Toubro Limited versus State of Jharkhand and others, 2017, 13 SCC 780, in support of the ground that the assessing officer has, without recording personal satisfaction, initiated the reassessment proceedings simply on the audit objection, which is not proper in the eye of law, based on the audit objection alone, which is not proper in the eye of law. Stop. On consideration of the submission of learned counsel for the respondents have filed a counter affidavit defending the impugned order. Stop. However, on consideration of the submission of learned counsel for the petitioner, we are of the view that the petitioner has an alternative remedy of appeal or revision under Chapter 9 of the JVAT Act 2005, under Section 79, VAT Act 2000, Chapter 9 of the JVAT Act 2005. Stop. The counsel for the petitioner then seeks liberty to avail of the alternative remedy of appeal, revision. Stop. It is open for him to do so if permissible in law. Stop. Writ petition seeks remedy with the permission to withdraw this petition. Writ petition is accordingly dismissed as withdrawn with the aforesaid liberty.
Revision, I may be given liberty to avail either appeal or revision, my lord.
Very well. तो फिर वो
उसमें खाली वही लिया जाए अल्टरनेटिव रेमेडी आइदर सेक्शन 9 और 84.
Very well. Available under the law.
सेंट्रल का है, उसमें सी फॉर्म का मामला है, वो भी हम फाइल कर दिए हैं. नेक्स्ट केस इसी साल का है, वो सेंट्रल का,
दोनों का
और बाकी सारा फैक्ट सेम है.
Obliged. 1546 of 2017. That was given a court of
हो गया रिजर्वेशन Yes.
Yes. My lord, I am appealing for the petitioner, my lord. Petitioner challenged the order dated 19/12/2016 passed in way by the London Central Administrative Tribunal, my lord. My lord, case of the petitioner that petitioner is the legally wedded second wife of the deceased, my lord. After the death of the first wife, my lord.
With your lordship's leave, my lord, I'm only praying, my lord. I'm going to file my counter affidavit today itself, my lord. Therefore, I'm praying on the last occasion, copy was served upon me. I'm going to file counter affidavit in this case. So I'm praying.
Then you should have informed us yesterday, so that we were prepared not to go. Mr. Prabhat,
Sorry, my lord.
and counsel for the BSNL submits that counter affidavit is being filed today. So therefore, the matter may be adjourned for a short date. As when counsel for the petitioner, it's open for the petitioner to file rejoinder to the counter affidavit by the next date, at least 2 days before the next date. Matter will be listed on next Wednesday.
Item number 5765 of 2019, along with item number 8 to 12. It's a plea for the further.
Lordship, I am for the petition in this matter, Lordship. Lordship, the IA for withdrawal in this matter. So, Lordship,
Okay. In all these matters, the Commercial Taxes Tribunal has remanded the matter.
Yes, Lordship.
So we will take note of the statement in the IA and
Yes, Lordship, the reason is stated at pair number 4 of my IA, Lordship.
right. In all the writ petitions you have filed, those are in IA.
Yes, Lordship. Sorry.
In all those writ petitions, you have filed separate IAs.
Yes, Lordship, separate IA has been filed. So,
The order of the tribunal is also of different date in some of the cases.
Yes, Lordship, order are different.
Very good. So it's my selection. But case that order should drop. Content common. Writ petition was preferred with the following prayer. Para 1 ABC. Stop. During pendency of the writ petition, the learned Central Administrative Tribunal, learned Commercial Taxes Tribunal has disposed of a revision case का IA का para 4 से सबका अलग-अलग होगा और order सब में आइए देखिए has disposed of the revision case number so and so and remitted the matter to the appellate authority for passing a fresh order. Stop. In that, the Land Council for the petitioner therefore seeks permission to withdraw this writ petition as it has become infructuous. Stop. Having regard to the aforesaid facts and statements made through the instant IA, the writ petition is dismissed as withdrawn. Is disposed of as infructuous. Sare mein
My lord, appearance of state council may be given, Your Lordship.
7 से 12 में सबका separate prayer और IA में para 4 सब separate division number सब check कर. For the state, Mr. Deepak Kumar Dubey, AG2 in all the matters.
In 3 matters, Your Lordship.
Your Lordship, in serial number GA3.
Send your appearances to the state.
Yes,
Obliged, Your Lordship. Much obliged.
Yes. All IAs are disposed. Individual जिस पे जो IA है वो disposed हो.
Item number 30, PA number 30 of the final time. Ms. Amrita Sinha for the
Your Lordship, in this case, I have sent an adjournment request, Your Lordship, for adjourning the matter upon the consent of both the sides.
For which
Your
what
Lordship,
reason?
I'm very.
Why are you seeking adjournment?
The adjournment is being sought, Your Lordship, for the reason that some instruction also need to be taken, Your Lordship, although it is above the monetary limit, and plus more so, Your Lordship, I'm not ready with the matter also.
So how much time do you require?
Let it be after Holi, Your Lordship, or
Ms. Amrita Sinha, learned counsel for the appellant income tax department, has prayed for an adjournment for which email was also circulated yesterday, with consent of the other side. So, as prayed for, matter is adjourned for 3 weeks.
much obliged, Your Lordship.
Other
Obliged,
side,
Your Lordship.
Mittal.
Obliged, Your Lordship.
Very good.
item 14, PA number 36 of 2020, Mr. Rahul number for the offline.
May it please, Manoj. Manoj, in this matter, Manoj, notices have to be issued, but Manoj, the tax effect appears to be lower than the monetary limit, but there appears to be an exception also, since there is a prosecution which is going on. So, Manoj, I am praying for 2 weeks' time to just to be sure of this.
You file affidavit whether it is maintained.
Mr. Rahul Lamba, learned counsel for the income tax department, seeks and is allowed 2 weeks' time to take instruction as to the tax effect of the disputed amount and whether it falls within any of the exceptions of the circular prescribing monetary limit for preferring the appeal before this court.
Manoj, I send that circulars, relevant circulars with respect to monetary. Manoj, got it, Manoj?
We have got it. We have seen it. Thank you.
PA number
16, 17 जरा कॉल करिए 16, 17, 18 ये जर्नल for prayer है 16, 17 Wait Mr. Pasari for a few cases.
Yes, Manoj.
16, LPA number 7 of 2021, along with item number 17. Mr. Samir Saha for
Who has prayed for an adjournment in these two matters?
My Lord, I am appealing for the respondent along with my friend Mr. Saurabh Shekhar, my Lord. I have prayed, my Lord, that matter may kindly be fixed for 14th of this month, my Lord.
Any particular reason?
My Lord, the reason is, my Lord, that the physical hearing, the matter has to be heard finally. Earlier also, my Lord, the matter was listed.
You are from outstation.
Yes, my Lord, I am out station counsel, my Lord.
14th Monday.
14th January 2000. So, Mr. Saurabh, Saurabh, you are representing most of the private respondents.
But I am representing the petitioners, my lord.
In the
No, writ petitioners. Yes, my lord. Most of the private respondents.
Yes. In fact, all of them.
all of the writ petitioners who are private respondents.
Yes, my lord.
14th March. Other side, consent has been taken.
I have informed my lord state as well as interveners, my lord. So, Kumari Sugandha, she is appearing for the interveners. Appellant in the second case, and in first case state, my lord, Miss Vandana Singh, my lord. I have informed her day before yesterday itself.
On the request of learned counsel for the writ petitioner / respondent, Mr. Rajiv Srivastava,
Rajiv.
assisted by Mr. Saurav Sekhar, with the consent of the other parties, closed these cases on 14th March 2021.
Much obliged, your lordship.
We are appealing.
Where you will send your appeals.
On 30th March, Lord.
14th March.
14th March.
I love. चलो चलेगा unless I can offline.
Item 80. First appeal number 14 of 2021, Mr. Ravi Kumar, for the appeal. Mr. Ashish Kumar Sekhar, for the appeal.
Who is appearing for both sides?
For the respondents.
This is against section 25 to order under Hindu Marriage Act.
Yes, Lordship, in this case, I am a respondent and I had also preferred an FA, that is FA 10 of 2022. So I pray that both the cases may be taken up together.
FA number?
FA number 10 of 2022.
10 of 22 has been filed by respondent.
Yes, Lordship.
So you had also prayed for enhancing the maintenance.
Yes, Lordship. In fact, the court below has decreased my maintenance from 18,000 to 9,000, and I had challenged that order, and they are saying that the maintenance may be further reduced to 6,000.
In that case, the husband has appeared.
No, Lordship, that case was not listed.
Mr. Ashish Kumar Sekhar, learned counsel for the respondent wife, submits that FA number 10 of 2022 has been preferred against the same impugned order.
Yes, Lordship.
By which the maintenance amount of rupees 18,000 per month has been reduced to rupees 9,000 per month in favor of the husband. Same impugned order passed under section 25(2) of the Hindu Marriage Act 1955 in civil miscellaneous case number 3 of 2020 on 24 July 21 by learned family court Bokaro. Stop. It is submitted that the husband has preferred this appeal, seeking further reduction of the monthly maintenance amount to rupees 6,000 per month. Stop. As prayed for, list the case along with FA number 10 of 2022 in the next week.
Lordship, in the meantime, I pray that they may be asked to pay the maintenance. Lordship, from last 3 years, they are not paying a single penny. They are just
म्यूट हटाइए मिस्टर अरविंद कुमार, म्यूट हटाइए आप.
Lords, sorry, my lord, I was delayed, my lord.
आप अपियर कर जाइए FA 10 of 22 में फॉर हस्बैंड.
Lords,
Next week में both the matters will be there.
my. All right.
Mr. Arvind Kumar, Land Counsel for the husband, undertakes to appear in FA number 10 of 2022 for the husband who is respondent therein by filing wakalat.
Lordship, they are not paying the maintenance which was allowed by the miscellaneous case number 1 of 2019. Lordship. From last 3 years, they are not paying anything to the wife.
Next week we will see that. Let both the appeals come together.
Online.
Item 21, WPT number 319 of 2022. Mr. Piyush Prasad for the petitioner, Ms. Amrita Sinha for the
May I please, Your Lordship? In this matter, Your Lordship, I have filed my counter affidavit wherein I have written that. Yes, Your Lordship.
When
Your
When
Lordship,
you have
what is
filed,
counter is not on record.
counter has already been filed, Your Lordship. It was filed on 25th of February itself.
It is not being placed on record.
नहीं नहीं 28 को हुआ है, हम लोग का कॉपी में 28 दो लिखा हुआ है. We have received the counter affidavit.
Very well. Are you filing any rejoinder or?
No, in the counter. बोलिए.
In the counter affidavit, I have stated, Your Lordship, that on 26th of February 2022, they have filed again an application for reconsideration of their case, and the case was reconsidered, and we have agreed to issue the lower deduction certificate at the rate of 1.3 after deducting, and as already 8.15 crore has already been paid by way of TDS, so we are agreeable to issue nil deduction certificate in the present matter, Your Lordship. So the grievance of the petitioner has been satisfied in that case.
But so far we have not received the certificate, Miller.
Okay.
Actually, due to some technical glitches, it was not uploaded, but it will be uploaded today itself, Your Lordship, by today or tomorrow. However, I have received the mail.
It will be. We'll record your statement that it will be uploaded by Friday latest.
Yes, Your Lordship, it can be.
So this can be disposed of in view of your categorical statement in which paragraph of your counter?
Yes, Your Lordship, that I have stated in para 4. Para 4 detail I have stated. There are sub-paras of para 4. In sub-para at page 5, I have stated. May I just read it, Your Lordship?
Yes.
In this regard, a copy of the writ petition was received. The matter has been reconsidered by the incompetent CIT TDS Patna, and he is agreeable to granting administrative approval for a lower deduction certificate, providing the outstanding demand visible in the system as was done in the financial year 2020 and 21, and against which the petitioner had no objection. A new application from the petitioner has been received on 26/2/2020 for nil deduction, and it is under consideration in the view of the above fact. And in the subsequent paragraphs, we have written that yesterday itself I received a mail, Your Lordship, that they have agreed for it and they will be issuing the certificate on nil deduction. As already 8.15 crore has already been paid by way of TDS till today.
These statements are in your email.
Yes, Your Lordship, that statement is particularly in my email.
That you can forward, we can put it on record.
I will be forwarding that, Your Lordship. I will be. Just now I am forwarding it.
Yeah, counter. We'll take it up after one case. The counter affidavit is coming
Yes, Your Lordship.
from the office. Item 98 was the pending matter.
Item 90. WPC number 396 of 2021, Mr. Nitin Kumar Prasad.
Mr. Sachin, have you taken instructions in this matter after the last date?
Lord, I have taken instruction. Actually, my Lord, the order earlier to be shared with Lord. This is the same, my Lord, same notice is there. So, Lord, so you can pass the same, my Lord, same order as was passed in this, my Lord, WPT number 2444 of 2021, my Lord.
Why your department wants to burden us by passing?
That issue is there, my Lord. Was there, we should, my Lord, your Lordship can dispose of, my Lord, simply by, in terms of this order, my Lord, without going into, my Lord, detail. It
So
will be
we will
disposed of in the
say
same.
that we will say that you have instructions to submit that the writ petition is covered by the judgment rendered in NCAS case WPT 444 and
If your
therefore
Lordship, permit me, my Lord, it may be written otherwise. If your Lordship, that I am not in a position to dispute that the notice
no,
earlier request, the further notice is similar to the notice earlier request. Because, my Lord, no written instruction is there in my hand, so, my Lord, I am submitting.
Her learned counsel for the petitioner. Mr. Pasari, you are appearing alone or Mr. Kurmi is also there?
No, Millet, I am appearing in this matter along with Siddhi Jalan, Millet.
Okay.
It's a very small matter, that is why, Millet.
Writ petition has been preferred for the following reliefs. Para 1, A, B, C, D, E. Stop. And what about the blocking of the IPC, Mr. Sachin?
Millet, they have not yet unblocked it. Although they had said on the last occasion that we are taking care of it, but that has not been unblocked as of now.
My Lord, DCM will be taken by the department, with regard to that.
So the 1 year period has already crossed.
My Lord, this writ petition is pending, my Lord. Writ petition was pending. So, you also can fix, my Lord, a time schedule within which, my Lord, it will be decided.
There is no question of limitation for proceeding afresh after the matter is disposed of in terms of NKS.
No, Millet.
It relates to 2018-19. So
yes, Millet. So 20, they have time, Millet. They have time.
3 years, my Lord.
73 time.
Yeah.
ये तो 74 का proceedings है ना 73 का
74 में पाइए
Petitioner, a registered dealer involved in the business of AS works contract and also mining related activities is registered with the State Taxes Department, Government of Jharkhand under Jharkhand Goods and Services Tax Act 2017 within bracket JGST for short. Stop. he utilized the amount of input tax credit against output tax liability on the amount of tax paid on purchases as per GSTR 3B return. Stop. However, his return were scrutinized and scrutinized for the financial year 2018-19, and a discrepancy of rupees 6.717 lakhs was found on mismatch slash difference between GSTR 2A and GSTR 3B, which he was asked to explain by notice in form GST ASMT 10 dated 18th December 2019 in Exchequer 2. Stop. Petitioner replied on 4th November 2019 enclosing a summary chart of difference between GSTR 3B and GSTR 2A, claiming that it is only rupees 44,303 and not rupees 6.17 lakhs as claimed by the department. So, however, no response was received from the department for about 1 year, for more than 1 year. But petitioner was surprised to receive a summary show cause notice in form GST DRC 01 dated 20th October 2020, alleging that he has claimed excess ITC for the period April 2018 to March 2019 and was asked to reply as to why tax, interest and penalty to the tune of rupees 14,36,896 be not imposed on him. Stop. A notice under Section 73 of the JGST Act was also served upon the petitioner on the same date, 20th October 2020, in Exchequer 4. पिछला वाला Exchequer 5. पीछे summary है Exchequer 4. Directing him to furnish a reply with supporting documents in stop. Petitioner furnished his reply on 29th October 2020, requesting the respondents to recalculate the difference between the difference in GSTR 2A and GSTR 3B and agreed to pay any excess ITC claimed by him if there was a difference, if it was in excess of the tax paid. According to the petitioner, the discrepancy mentioned in GST ASMT 10 differed from the demand details in the summary notice under Section 73 of the Act. However, according to the petitioner, without taking notice of the reply, a summary order has been issued in form GST DRC 07 on 14 December 2020 imposing tax, penalty and interest to the tune of rupees 14,36,896 on account of excess ITC availed. Petitioner has further averred that his electronic credit ledger has been blocked to the extent of rupees 10,18,942 on 5th March 2020. And again, an amount of rupees 4,21,698 was blocked. Stop. Such ITC remains blocked for more than a year in teeth of Rule 86A3 of the JGST rules. Stop. Petitioner, Land Counsel for the petitioner, Mr. Pasari, Land Counsel for the petitioner has has at the outset taken a plea that the proceedings are not in accordance with law. Proceedings under Section 73 of the Act are not in accordance with law, as the show cause notice under Section 73 issued on 20th October 2020, Annexure 5, by the Deputy Commissioner Godda does not indicate any contraventions committed by the petitioner. Stop. The show cause note SCN is in a format and none of the irrelevant grounds have been struck off. Stop. He submits that the show cause notice cannot be a substitute. No, a summary of show cause notice under DRC 01 cannot be a substitute of the show cause notice statutorily required to be issued under Section 73(1) of the Act. Now, then counsel for the petitioner has relied upon the decision of this court in the case of NK Services Private Limited versus State of Jharkhand and others, WPT number 2444 of 2021, dated 6th October 2021, and also in the case of the same petitioner, वो email से भेजे थे ना, दूसरा वाला judgment भी आया है।
Yes, that is WPT 2659 of 2021.
2659 of 2021.
And the judgment dated is 9th February 2022.
9th February 2022.
Yes, Manoj.
Relating to similar show cause notice issued under Section 74 and Section 73 of the JGST Act respectively in both the petitions.
Yes, Manoj.
Stop. Then counsel for the petitioner submits that the writ petition would be maintainable despite availability of statutory remedy under Section 107 of the Act, as there is a violation of principles of natural justice and the procedure prescribed in law to initiate such a proceeding under Section 73 of the Act. Stop. In support of this submission, he has placed reliance upon the opinion of the Apex Court in the case of Assistant Commissioner of State Tax and Others versus Commercial Steel Limited, reported in 2021, SEC Online, Supreme Court 884, Para 11 and 12. No, Para 11. Stop. Land counsel for the petitioner has also relied upon, besides the provisions of Rule 86A3, also relied upon the judgment of the Gujarat High Court in the case of Alpha Enterprise versus State of Gujarat, 2019 within bracket 31 JSTL 592 Gujarat. Relating to blocking of the ITC.
It's paragraph 6 and paragraph 8.
Para 6 and 8 thereof. Stop. Reliance is also placed on the case of Vimal Petrothin Private Limited versus Commissioner CGST rendered by the High Court of Uttarakhand at Nainital, reported in 2021 within bracket 53 JSTL 130 within bracket Uttarakhand. Stop. He submits that the ITC cannot remain blocked for more than 1 year, as per the restriction contained in Rule 86A3 of the JGST rules. Stop. Respondents have appeared and filed counter affidavit. Stop. Then counsel for the respondent has referred to the contents of the counter affidavit and the Gazette notification dated 10th February 2020 issued by the government of Jharkhand, which brought into force Rule 86A into the statute book, which empowers blocking of electronic credit ledger on the conditions specified under sub-rule 1 thereof. Stop. And counsel for the respondent, however, submits that does not dispute that the electronic credit ledger of the petitioner has remained blocked for more than 1 year. Stop. Then counsel for respondent has also placed reliance on the case of GlaxoSmithKline the Assistant Commissioner within bracket CT, LTU, Kakinada and others versus GlaxoSmithKline Consumer Healthcare Limited, reported in AI 2020, Supreme Court 2819. In support of the plea that the writ petition won't be maintainable before this court. Stop. And counsel for the respondent has also stated that वो GlaxoSmithKline का छोड़ दीजिए, ये जो लिख रहे थे गैजेट ना वो भी हटा दीजिए. Then counsel for the respondents has submitted that on account of a difference in the difference or mismatch of rupees 6,17,515.30 in the GSTR 2A and and the return filed under GSTR 3B, show cause notice was issued upon the petitioner. The summary of the order under GSTR DRC 07 was issued after service of notice upon the petitioner, against which a remedy of appeal lies. Stop. However, learned counsel for the respondent does not dispute that the case of the petitioner stands covered by the decision of this court in the case of NCAS Services Private Limited, WPT number 2444 of 2021, in relation to a show cause notice under section 74 of the JGST Act, and also the case of the same petitioner NKS Services Private Limited versus State of Jharkhand in WPT number so and so, judgment dated so and so, wherein this court has categorically held that the impugned notice lacked in fulfilling the ingredients of a proper show cause notice under section 73/74 of the Act. Stop. This court has also held that a summary of show cause notice as issued in form GST DRC 01 in terms of Rule 142 within bracket 1 of the JGST Rules 2017 cannot substitute the requirement of a proper show cause notice. Stop. दूसरा वाला जजमेंट ईमेल से लोग बोले थे Mr. Pasari, you had sent the other judgment of NCAS
Yes,
to
Manoj.
mail.
Yes, Manoj. 2659 via mail I had sent last week itself.
I have seen it yesterday.
Manoj, the said judgment, paragraph 11 onwards is relevant, Manoj. In 2659.
Print out निकाल दीजिए.
2659 of 21.
2659 of 21. Judgment dated 9th February.
Yes, Manoj. Paragraph 11 to 16, Manoj.
Then counsel for the respondent state AG2 submits that in that event the matter may be remanded to the state tax officer to initiate fresh proceedings in accordance with law after service of a proper show cause notice under section 73 of the Act. Stop. We have considered the submission of learned counsel for the parties and taken note of the rival pleas in the factual gamut of the case of the petitioner. Based from the pleadings on record, we are constrained to say that the impugned show cause notice at Annexure 5 is as under. The summary of show cause notice at Annexure 4 उसके बाद is as under. A perusal of the impugned show cause notice, Annexure 5, issued under section 73 shows that it completely lacks in fulfilling the ingredients of a proper show cause notice under section 73 of the Act. It doesn't contain any averments as to the contravention committed by the petitioner. It has been issued in a format without striking the irrelevant particulars. In the case of NKR Service Private Limited, WPT 2444 of 21 concerning a similar show cause notice under section 74 of the JGST Act, and also in the case of the same petitioner NKR Services Private Limited in WPT number 2659 of 21 relating to a similar vague show cause notice under section 73 of the Act. This court, by detailed judgments dated 6th October 21 and 9th February 2022, quashed the notices impugned in those writ petitions on same grounds. And granted liberty to the respondents to initiate fresh proceedings from the same stage in accordance with law within a period of 4 weeks from the date of the order. Stop. For the same reasons, we are inclined to quash the impugned show cause notice under impugned show cause notice issued under section 73 of the JGST Act and the summary of the show cause notice issued in form DRC 01. Stop. Since the breach relates to violation of principles of natural justice and the mandatory procedure prescribed in law, guided by the decision of the apex court in the case of Magad Sugar and Energy Limited versus State of Bihar and others, reported in 2021 SCC Online Supreme Court 801, para 24 and 25, as also the principles laid down at para 11 in the case of Assistant Commissioner of State Tax and others, Supra. We are of the view that the writ petition is maintainable. So, accordingly, the impugned notice at Annexure 4, summary of the show cause notice at Annexure 4 and the show cause notice dated so and so at Annexure 5 are quashed.
Milot, Annexure 7 also has to go, Milot. The DRC 07.
Okay. Consequently, the summary of the order issued under issued in form GST DRC 07 also cannot survive. So it is accordingly quashed. They have not issued any formal order to you, or have you applied?
No. Not even annexed in the counter affidavit also.
वहाँ लिख दीजिएगा. And counsel for the petitioner submits that the order passed under section 73 has not even been brought on record, if any, has not even been brought on record and by way of through the counter affidavit by the respondents. By way of counter affidavit, through the counter affidavit by the respondents. Stop. Petitioner can prefer an appeal only if the proper order passed under section 73 could have preferred an appeal. Otherwise, an appeal could have been preferred only if a proper order under section 73 is passed instead of the summary of the order being uploaded in form GST DRC 07. Stop. Since the court has not gone into the merits of the challenge, respondents are at liberty to initiate fresh proceedings from the same stage in accordance with law within a period of 4 weeks from today. The writ petition is allowed in the manner and to the extent indicated above. Stop. Needless to say, उसके ऊपर में कही, the respondent should also take a decision on the question of blocking of the ITC of the petitioner in accordance with law within the same time.
Much okay.
Yes, Your Lordship, I have forwarded the mail.
Is item 20?
No, it is the last admission matter. Yes, so in your counter affidavit, the paragraph is para 4.
Para 4, the entire fact is stated, developed subsequently, and in para 5, it has been specifically stated, and para page 4 and page 5, wherein I have specifically stated, Your Lordship.
So it's basically para 4.
Yes, para 4 entire mechanism.
Third learned senior counsel for the applicant, Mr. Hiren Podar and Ms. Amrita Sinha, appearing for the respondent income tax department. The petition was preferred for the following reliefs. Paragraph 1. A, B, C, D. Detailed facts relating to the case of the petitioner need not be gone into because of the specific stand of the respondents brought on record through their counter affidavit. Stop. Then counsel for the respondent has in particular referred to para 4 of the counter affidavit, which at the end states that the matter is being considered by the incumbent CIT within bracket TDS Patna for and he is agreeable to grant administrative approval for a lower deduction certificate provisioning the outstanding demand visible in the system as was done in FY 2020-21 and against which the petitioner had no objection. Stop. A new application from the petitioner has been received on 26 February 2022 for nil deduction certificate within inverted comma and is under consideration. Stop. Then counsel for the respondent has stated that stated on instructions received through mail on second yesterday
Yes, on first.
from Patna Society TDS to the effect that approval for issuance of lower/nil tax deduction certificate under section 197 of the Income Tax Act 1961 has been accorded. Stop. Due to some technical issues on traces, capital traces, log in, the same could not be uploaded on the traces portal. The approval could not be uploaded on the traces portal. Stop. The email encloses the attachment of the approval
May I just read the relevant part of the attachment?
Yes.
Your Lordship, first attachment is, so far as concerned, that is 22184. In this, at the bottom, it is stated that the same issue were considered for issuance of lower deduction certificate during financial year 2021 instead of nil deduction certificate for financial year 21-22. However, till date TDS of rupees 8.15 crore has already been deducted, so there is no need to provision for the demand, and a nil deduction certificate may be issued.
Yes.
And in the second comment, it has been stated, comment provider, in the instant case, the estimated cost of the SSE is rupees 508.83 crore for the financial year 21-22. However, after the set of previous year's loss, the net income is in negative. Further, there is a total manual and CPC processed outstanding demand for the previous year are 1.80 crores altogether, whereas through TDS/TCS an amount of rupees 8.15 crore have already been withheld during the year. Considering these facts, nil deduction certificate under section 197 of the Income Tax Act may be given if deemed fit.
Then counsel for the respondent has referred to the relevant extracts of the attachment containing the comments of the Deputy Commissioner of Income Tax TDS Circle Ranchi, which is quoted here under. The first paragraph, the last paragraph in the first page we are going to quote, Ms. Amrita.
Ji, Your Worship.
Stop. Then counsel for the respondent further states on instructions that the approval is likely to be uploaded on the traces portal, traces capital, today itself, but latest by Friday. Stop. Para. Learned Senior Counsel for the appellant submits that in view of the categorical statements made by the respondents in the counter affidavit and on instructions by learned counsel for the respondent, the grievances of the petitioner appear to have been redressed. Stop. Let the email containing the instructions be taken on the board as well. Having regard to the specific stand of the respondents relating to issuance of the nil deduction certificate under section 197 of the Income Tax Act 1961, it appears that the grievances of the petitioner have been satisfied. The writ petition is accordingly disposed of. Item 15.
After the case, item 15, WPC number 3247 of 2020, and Sri Kumar Prasad for the case.
Your Lordship, I was praying for a short Passover in this case.
Pass over.
Oblige, Your Lordship.
Item 20, WPC number 1949 of 2021. The Supreme Court for the petitioner, the law of the Council.
My lord, I am led in this matter by Mr. Kurmi. Nobody is there.
Oh,
May it please the Lordship.
yes.
My lord, this is a case under the Direct Tax Viwas Act, my lord, 2020.
Yes.
My lord, I am aggrieved by the decision of the respondent, which is at page, my lord, kindly see, last but one page, my lord, Annexure 16, 173, rejecting my declaration, my revised declaration under the Direct Tax Viwas Act 2020. Last but one page, my lord, Annexure 16, page 173. It is a snapshot which has been typed out. No formal order has been sent to me. From the portal, I could see that my application has been rejected. Being aggrieved, I filed the petition, my lord. So, my lord, kindly see. It reads, my lord, filing type revised. Could your lordship get it? Filing
Yes.
type revised. Remarks means the reason of rejecting by virtue of section 9C of the Direct Tax Viwas Act 2020. Date of rejection 15/3/2021. I'll kindly note the word rejection. I will check your lordship to these words also. And my contention is that under the Act, there is no power to reject. There is no power to reject. Only certain presumption can be drawn under certain circumstances that no declaration is filed at all. Under certain circumstances, it can be deemed that no declaration is filed, but there is no power to reject. The power to reject is not there, my lord, because there were certain schemes that came earlier prior to the present scheme in which this power to reject was there. And it was found that instead of meeting the objective of the legislation to settle the dispute and free the money blocked in litigation, the department going into technicalities were rejecting all the applications and only few applications were allowed, and the purpose of the act was frustrated. That is why in all modern legislation now enacted by the parliament, this right of rejection is not there. Authorities cannot reject. So, my lord, I am challenging mainly on the ground that invocation of 9C, which is placed into service, not have been invoked against me. This is a revised declaration, my lord. Prior to this declaration, a declaration was already filed. In that declaration, as per section 7, I was to get a refund of 20 lakh rupees in my declaration. But when the certificate was issued, a demand of 9 lakh was raised on me, ignoring the 20 lakh rupees of payment made by me to the extent 20 lakh rupees. So I approached the department and I was advised to file a revised declaration. So I filed a revised declaration showing that I am entitled to refund of 20 lakh rupees, and the earlier certificate issued to me demanding 9 lakh rupees is not correct. So that revised declaration is now rejected on a new ground. So initially I filed a declaration claiming refund of 20 lakh rupees, because that 20 lakh, the amount under the Act, my lord, which is paid prior to filing declaration. Any excess amount paid prior to filing declaration, if it is excess than the amount determined, is refundable. Not after filing declaration. I will take your lordship to the Act. In this case, the amount was paid by me prior to filing declaration, So I claim that it was filed prior to declaration, so I am entitled to refund under section 7 to an amount of 20 lakh rupees. But while issuing certificate, they ignored certain amount and raised a demand of 9 lakh on me. Then I approached department saying that no, I have paid certain amount prior to filing declaration, so I am entitled to refund of 20 lakh rupees. 9 lakh demand is wrong. They advised us to file a revised declaration. We filed a revised declaration, again claiming a refund of 20 lakh rupees after adjusting the tax liability under the act. That is rejected now by this decision, which is impugned, my lord. So the ground of rejection, my lord, is that by virtue of section 9C of the Direct Tax Vivad Se Vishwas Act 2020. My lord, kindly have the act, my compilation, my lord. My compilation, my lord, kindly have page 16, my lord.
अच्छा इसमें है मैंने चेक किया
आपके पास
मैं कुछ सेटअप
मास्टर उनका काम होना चाहिए इसमें थोड़ा मेरे पास भी है इसका मतलब पहले दिया
पहले पता नहीं किसमें फाइल है
कोर्ट मास्टर ने सब कुछ हाँ बैठा होता है सभी में चेक करके रहता है रात में 10 बजे There is one difficulty, Mr. Kurmi.
My lord.
And not an ignorable difficulty. That the second set of all these compilation, perhaps which was filed, obviously filed, because I have that set, that is not with brother. Because that might be in the either in the section or maybe the chamber of sister earlier where it has.
In fact, my lord, I had filed it on Friday, and I had spoken also that it may go to your lordships. I filed it much advance.
So this was these three compilations, two thin and one thick.
Yes.
They have been filed when?
On Friday, my lord, we had given it in the court to the learned court master, my lord. And I even checked that whether it.
Well, there is one compilation, my lord, one compilation.
Then we will hear it on some other day because brother has not been able to go through. I had the privilege of going through all the grounds which you have taken and facts also.
My lord, there is one compilation, one written notes, and one gist of cases, my lord.
Yes. Gist of case laws is there, written submission is there, and there is a compilation of statutory provisions and case laws.
My elder sister has also filed counter, and we have filed rejoinder, my lord.
Counter is there. Counter, those things which are on record are there.
Counter rejoinder.
Today in the morning, I have also sent one judgment and one circular.
Yes, my lord. Today morning she has shared with me also.
लेडी के साथ करिए शुरू करिए
Just now it has come. So what we propose is that we will hear you today.
My lord.
You may formulate your grounds. If necessary, it might spill over to another day.
My lord. So, my lord, in that compilation, kindly have page 16, my lord.
Yes.
We have seen the impugned decision in which, my lord, the ground was, if your lordship would take trouble, kindly have a glimpse of it again, my lord. Annexure 16, page 173.
Madam, can I take leave? My colleague Akansha is here. She will be assisting.
Yes.
Oblige, madam.
So, my lord, annexure 16, page 173, my lord. What is thought to be rejected is the revised declaration.
Yes.
Filing type revised. And remark, purportedly, this is the ground for rejection by virtue of section 9C of the Direct Tax Vivad Se Vishwas Act 2020.
Yes. Yes, Mr. Kundu, please go ahead.
And date of rejection is, my lord, 15/3/2021.
Yes.
So, as I stated, my lord, there is one declaration already filed earlier. In the petition, kindly see, my lord, that declaration is at page 142, that is annexure 12. That is the first declaration. While, my lord, see page 152. 142 it starts. 142 is the date. Dates are important, my lord.
Yes.
Dates are important. I filed my first declaration on 24/12/2020. Page 152, my lord. And that declaration was accepted by the respondent. That is on page 160, my lord.
Just a minute, just a minute. 24 December 20.
My lord, this is the date on which I filed my first declaration. And my
Yes.
thus first declaration was accepted by the respondent by annexure 14, page 160.
Yes.
And the date, my lord, kindly see page 161 at the bottom. The date is 20th January 2021.
20th January 21.
Yes, my lord.
What
At the
is
bottom,
this?
kindly see
What
page
is-
161.
This is acceptance of the declaration.
Yes, they have accepted and they have settled my all disputes. But raising a demand of 9 lakh rupees, kindly see just there before of that, my lord. One amount is there.
Yes.
On or balance amount payable after, on or before 31st January 2021, it is 9,08,075. Just 2, 3, 4 lines just above that, my lord.
Yes, yes.
So, my lord, what they say, pay this amount by this date and your entire things are settled. But my contention was that, kindly say of that there is table, my lord. Certain entries are showing as mismatch. In the table, my lord, certain entries are showing
Yes.
mismatch. These payments are not considered on the ground that these are already adjusted in the assessment order. So don't show it here. Don't show it in the declaration filed by you in the declaration that we had shown. So we were advised to file a revised declaration. That we filed, my lord, page 162 and 15. Page
No,
150.
This inference that you were asked to file a revised declaration is your own inference, not a specific instruction from that.
Yes, that's correct. This is my averment, I am saying, and it is a fact also. But let us go by, my lord, what I am submitting. Let us go by that. And I will show that if I don't succeed in substantiating my revised claim, then also nothing turns against me.
No, suppose you did not file a revised declaration.
My lord.
In that case, what could have been the fate? This was an accepted one. This could not have been rejected in any case thereafter.
My lord, in that situation, I would say it was a case of mistake apparent on the face of record.
Whatever it is,
Yes,
we are
it is
just
an.
trying to understand the subtleties of the two, filing of a revised return, and if you did not file it, then this was something which they could not have
Correct,
rejected.
my lord.
It could have been, Your Lordship. Presumption, Section 7 of the new Act, of the Vivad se Vishwas Act, it could have been.
So, my lord, my point is that the
Could
first
have
order.
just a minute, Mr. Section 7 of the same act, what does it say?
Yes, Your Lordship. Direct Tax Vivad se Vishwas Act.
Page, kindly see, my lord, page.
Not 7, Your Lordship. I'm so sorry. Section 4, subsection 6.
That's right, not section 7. 6. Never to have been made if any methodical furnished in hand is found to be false.
Yes, Your Lordship. At any stage.
Huh?
But false card. That is not
the charge sheet or the cognizance was after filing of that declaration.
Yes.
That I will be coming, Your Lordship. How it can be that I will be coming on that point, Your Lordship,
Yes,
and
ma'am.
I will be arguing.
That is the point here. That's why I said that dates are very important. So, my lord, kindly see, my lord, that very technical thing that I would address now, that if I would not have filed revised declaration, that the declaration, the certificate issued by them would have attained finality. But the thing is that the certificate has to be issued in accord with the act, not dehorse the act.
So, in monetary effects, the monetary terms, the effect of this acceptance could be that 9,80,075
इनको payment.
आपको पेमेंट करना था,
My lord.
and the rest of it which you are claiming in the declaration, that would have been treated as disallowed.
No, it is, yes, they are not considering it. My point is that, my point is that it is not a case where the declaration cannot be accepted at all. By invoking 9C, one cannot say that declaration cannot be accepted, file at all, or I am ineligible to file it. My point is that, now coming to the differential amount, going by certificate, I had to pay 9,08,000 only. So I don't accept, challenge that one. But if I challenge that, and I would say that as per section 7, the entire amount paid by me, as per the act, has to be given a credit adjustment, and thereafter the amount is deducted. It's only a technical plus minus.
No, but whether the provision of this act does provide a kind of a proceeding in the nature which the SSC is contemplating, that your return whenever you file, your declaration whenever you file, if some mismatch is noticed by the department and that is not accepted, then you will be given an opportunity to file a revised return, and then the department is under an obligation to consider it again. Whether the act is in nature of such a detail, having a detailed procedure to undertake this kind of a proceeding.
I will take your lordship that also in the act, my lord. I will take your lordship. But the thing is that the department now, they are not disputing it. They are not rejecting my revised declaration on this ground. They are rejecting my declaration on the ground of 9C. They are not saying you are not entitled to file. On that point, there is no list between the parties. Only 9C is invoked, saying that since the procedure is launched against one of the director, instituted against one of the director, that is why your revised declaration cannot be considered. That is the only point your lordship. That is the only issue.
That is what we asked Samrita, that this cognizance was taken after the filing of the first return.
Cognizance status, yes.
9C says has been instituted on or before the filing of the declaration of such, or such person has been convicted.
But your lordship, the FIR was lodged much before that, and the inquiry and the investigation initiated much before of the filing of the first declaration, your lordship. Although the date of the charge sheet is on 30th December 2020, however, the FIR was lodged way back in the year 2017 itself. And there is a judgment of the
My lord,
Honorable Supreme Court which have defined and stated particular the circumstances itself.
my lord, the cognizance is taken on 1st October 2021.
Charge sheet was 30th.
Charge sheet was filed on 31st December 2020.
After filing of your first declaration?
Yes, both. My first declaration and my second declaration. After that, the cognizance is taken. My first declaration I filed on 24th December 2020.
Yes.
I filed my revised declaration on 23rd January 2021, and
Yes.
cognizance taken on 1st October 2021. So the cognizance is taken after filing my first declaration and my second declaration both.
Charge sheet was filed after first declaration.
Yes, charge sheet was filed after the first declaration. So my lord,
what is the effect of that? Charge sheet was filed against a director. You have also taken a plea that the prosecution has not been launched against the company.
Correct, my lord.
And as per the general principles, that is acts of the directors and managing director, etc., bind the company in any criminal offense. But does the Income Tax Act also has similar provision that if there is a case against the director for an alleged offense, the company is also to be prosecuted as a what you call vicarious liability, or the company also becomes liable for being prosecuted for that?
My lord, my submission would be, in the charge sheet, no proceeding is initiated against the Income Tax Act. No prosecution under the Income Tax Act is there. It is under the Prevention of Corruption Act against the one more director. So, my lord, that prosecution
That case under Prevention of Corruption Act has been issued against the director in relation to the affairs of the company, or a totally unrelated affair?
Well, it is unrelated to the company. Company is not accused person. Well, I will show a charge sheet to your lordship. Company is not accused person. My point is that company is not accused person in the charge sheet. The accused person is one of the director of the company. Now we have to, my lord, we have to read the statute in its own words, in its own terminology used by the statute, the definitions of the statute and the provisions of the statute. The definition under the Act, my lord, the benefit under the Act is given to the declarant. and the exclusion is to the declarant only. Declarant under the Income Tax Act, if I go, then I would say company is a separate legal entity. If I say, I will not stop there, I would say the company is a separate HSE and the director is separate HSE. The circular issued by the board. Now, circular issued by the board also clarifies that the prosecution should have been instituted against the HSE who has filed a declaration. In this case, the declaration is filed by the company, not a director. The declarant is the company, not a director. The relief issued to the declarant, and who's excluded is the declarant. Under 9C, only declarant can be excluded. Those who are not declarant, how then they can be excluded by law? So 9(6) can be invoked only in circumstances where the declarant is facing a prosecution or a prosecution has been instituted against him. Kindly have a glimpse of section 9, my lord, page 21. Page 21, my lord, 9 at the bottom, my lord.
Yes.
The provisions of this act shall not apply. A. In respect of tax area, my lord, there are two categories. One category is respect of tax areas having connection with the tax area. And this other category I will take your lordship to. In respect of tax area, relating to an assessment year, in respect of which an assessment has been made under subsection 3 or section 143 or section 144 or section 153A or section 153C of the Income Tax Act on the basis of search initiated under section 132 or section 132A of the Income Tax Act, and if the amount of the disputed tax exceeds 5 crore rupees, it is such cases, my lord. Those are excluded. Then, my lord, clause 2, relating to an assessment year in respect of which prosecution has been instituted or before the date of filing declaration. Now, my lord, it is under the category tax area.
Yes.
The provisions of this act shall not apply in respect of tax area relating to an assessment year. Tax area in respect of an assessment year, relating to an assessment year in respect of which prosecution has been now instituted on or before the date of filing declaration. And tax area of the whom, my lord? Tax area of the declarant. So in this case, against the declarant whose tax area is sought to be settled, no prosecution is launched. And also the department is not saying that they are invoking A. They are not saying that. Then, my lord, 3, relating to any undisclosed income from a source located outside India or undisclosed asset located outside India. Then, Roman 4, relating to an assessment or reassessment made on the basis of information received under an agreement referred to in section 90 or 90A of the Income Tax Act if it relates to any tax area. 90 is, my lord, agreement with a foreign country, and 90A is, I would say, double taxation avoidance agreement. Then B, my lord, B is also coming under the tax area category. I'm sorry, my lord. B is independent. To any person in respect of whom an order of detention has been made under the provisions of the Conservation of Foreign Exchange and Prevention of Smuggling Act 1974 on or before the filing of declaration. I am skipping this one, my lord. B I am skipping. I am coming to C.
Yes.
The provisions of this act shall not apply to any person in respect of whom shall not apply to any person in respect of whom prosecution for any offence punishable under the provisions of Unlawful Activities Prevention Act 1967, the Narcotic Drugs and Psychotropic Substances Act 1985, the Prevention of Corruption Act 1988, the Prevention of Money Laundering Act 2002, the provision of Benami Property Transactions Act 1988 has been instituted. What? See the word instituted, and also any person in respect of whom.
Yes.
So if I read from 9 again, the provisions of this act shall not apply to any person in respect of whom the prosecution for any offence punishable under the provisions of this act has been instituted on or before the filing of the declaration, or such person has been convicted for any offence punishable under any of those acts. So here, my lord, against me, no prosecution has been instituted, and also the date institution is taken as the date of cognizance, then it is beyond the first declaration, also the second declaration. Then, my lord, also I am noting D, because in the counter affidavit in some places they have referred to D and E also to explain the purpose of the act. D, to any person in respect of whom prosecution has been initiated by an income tax authority for any offence punishable under the provisions of the Indian Penal Code, or for the purpose of enforcement of any civil liability under any law for the time being enforced on or before the filing of declaration, or such person has been convicted of any such offence consequent to the prosecution initiated by an income tax authority. E, to any person notified under section 3 of the special court trial of offence relating to transactions of the Securities Act 1992 on or before the filing of declaration.
Yes.
So, my lord, in no case 9C can be placed into service against me. Company and its director are separate legal entities. Number one. Number two, Income Tax Act treats company as a separate HSC and director as a separate HSC. The clarification issued by the CBDT under section 10 of the Act clarifies that the prosecution should have been instituted against the HSC. If you lordship would kindly see to the compilation on page, my lord, 28. This is a clarification issued under the Act, my lord, and the relevant portions are on page 34, my lord. The clarification issued in the form of a question answer in exercise power under section 10 of the Act. So we are concerned with page 34, my lord.
Yes.
Question number 22. Question number 22. In the case of an HSC, prosecution has been instituted and is pending in court. Is HSC eligible for the Vivad se Vishwas? Further, where the prosecution has not been instituted, but the notice has been issued, whether the HSC is eligible for Vivad se Vishwas? Answer. Where any notice for intimation of prosecution has been issued without prosecution being instituted, the HSC is eligible to file declaration under the, see the word SSC, Vivad se Vishwas. However, where the prosecution has been instituted with respect to an assessment year, the HSC is not eligible to file declaration for that assessment year under Vivad se Vishwas unless the prosecution is compounded before filing the declaration. So, my lord, the entire scheme of the Act is declarant centric. It is declarant centric. The application is to filed by the HSC, who is a declarant. Certificate is issued to the declarant. Exclusion is to the declarant.
And section 9 prescribes the conditions of ineligibility of a person
Ineligibility.
who wants to become a,
my lord. And my lord, I would say, in a beneficial legislation, even if in the exclusion clauses, even if the wide words are used, keeping the objective in mind, the objective of this act here is to unlock the revenue blocked in litigation, and also to and put an end to litigation and save the valuable time and money and energy of the government, of the HSC and the courts. So this is the purpose of the act. So, my lord, is a beneficial legislation, and while reading the
Just
यहाँ पर टेक्निकली एक्सेप्टेंस ओके है, तो अगर ये रिवाइज नहीं फाइल तो फिर को सारा चीज में तब मिसमैच करने में फिर बाद में ब्लॉक हो गया।
Yes, Mr. Purni. We were at those question and answers, clarification. You'll have to unmute yourself, Mr. Purni.
On page 34,
Yes.
question answer I read. And the word assessing.
We were in the meantime looking to the further clarification sent by the Ms. Amrita on 4th December 2020 clarification.
My lord.
Trying to see that what is that clarification about. Perhaps Amrita would be relying upon question number 82.
82.
Yes, Your Lordship. On question number 82, I am relying upon.
So, does it help your case, your stand in the present case by relying upon that clarification?
Yes, Your Lordship, that will, and I will also be placing one judgment, Your Lordship, that is of 2007, volume 7. That judgment is also helpful, wherein it has been stated that a purposive construction have to be given to the scheme and the legislation. Although it has, yes.
That judgment is in relation to a partnership firm.
I completely agree, Your Lordship. That is in relation to a partnership, but the person is defined as a company, firm, individual, everything.
That is, for that they have relied upon 1955 judgment and Kapila Hingorani's judgment.
And declarant is defined in the this act.
The ratio descendant of that case I will be relying upon.
Ratio will
Even
vary.
the fact is slightly different.
Partnership, the partnership firm is vicariously liable. In income tax, both of them are separate SSCs.
Even under section 270, even under section 278B, which in the question answer 82, it state about the vicarious liability with respect to companies also, Your Lordship. 278B of the Income Tax Act.
No, that is filing
income tax penalties.
Income tax penalty relating to filing of false return.
Yes, Your Lordship.
So, suppose the declaration of a company is accepted and there was a proceeding in relation to a false return through one of its director, then the answer says that the company and its director who were responsible for filing that false return, they will get immunity. So it is in a context. Here the declarant is a company and the company is not facing any prosecution. The director is facing prosecution not in connection with any of the offences of the IT Act. It is facing prosecution in connection with a different act, PC Act. So the SSC is not the declarant that prosecute, the offender is not the declarant. He is under 9C, as we are trying to understand, under the ineligibility under section 9C would apply to any person who is facing a prosecution, whatever date, etc., we are not again going into, who is facing a prosecution on or before, etc., that person will not be able to file a declaration. There might be a host of categories of persons, but once he is ineligible, he doesn't come into the shoes of the declarant. Those who become eligible, meaning thereby under 9, they are not excluded. They can only come within the definition of declarant, which is indicated in the definition clause.
May I just submit, Your Lordship, in this extent? The first of all, Your Lordship, the case is with respect to, admittedly, it has been, steps has been taken against, prosecution has been launched against the director of the company. However, there is a direct nexus with the company, with the declarant in this case, because for the reason the case pertains to, Your Lordship, if we recall, it is the case wherein the other co-accused is also the income tax department officers also, wherein in connivance and in collusion with the income tax department, all the jurisdictional matter, all the cases of the company of the petitioner company were transferred from Kolkata to Ranchi or to Hazaribagh in order to take the illegal gratification and illegal advantage of the post of the certain income tax officers, and as per them, the income tax officer, the then income tax officer, quashed all the assessment orders of with respect to the companies, and then they, under section 264, they ordered for a, yes, your lordship.
Why is the company also not being prosecuted?
Your lordship, voice is not coming.
Why the company has not been prosecuted?
The company has not been prosecuted for the simple reason, your lordship, because the Prevention of Corruption Act, if we see, your lordship, therein it deals with the public servant and the person who is taking the gratifications, your lordship, or giving the gratification or involved in such things. And maybe because he has been prosecuting in the capacity of a controller of the petitioner company. He is being
that under the Prevention of Corruption Act, only the directors of the company can be prosecuted.
He is being prosecuted, your lordship, for the reason being in the capacity of the controller of the petitioner company. That is there stated in the charge sheet itself, your lordship. And from going through the entire Prevention of Corruption Act, it is centric to a person, your lordship, more particularly to a public servant. Section 21 of the particular act states that Section 21 of the Prevention of Corruption Act also states that the accused person to be a competent witness, any person charged with an offence punishable under this act, that is under Prevention Act, shall be competent witness for the defence and may give evidence on oath in disproof of the charges made against him. So for that particular reason, only the directors were made the accused in all the cases. However, they were made accused, if we go to the charge sheet, the detailed charge sheet is there. That was done with respect to the company itself. And therefore, the Honorable Supreme Court has also stated in one of the judgment, your lordship, that a direct nexus has to be there. If the direct prosecution is against the director, but a nexus is with respect to the company, then in that purpose it has to be taken in. And in this particular judgment also, which I have just submitted, your lordship, of Tanna and Modi, on the very similar ratio descendant, the court has proceeded. Even when the immunity under section, I may be relying upon question number 82, which says that when it comes to the immunity, it is given to the director also, not only to the company. It is also being given, a declarant is always a company. However, the immunity is being given to the director also, your lordship. And this particular question was also there in the, that time it was there in the voluntary disclosure scheme 1997, which judgment therein the similar question was put, and the Honorable Supreme Court said that when the immunity is being given on behalf of the director and also to the directors of the company or the partners, or and also to the company, then why not the prosecution? If there is a nexus between them, it has to be prosecuted. A purposive construction has to be given to the entire scheme. It cannot be said that for certain reason only the company is in, and for where it comes to the benefit of the directors, it is extended to the company as well as to the director. However, in the other case, only the company, because the company is a declarant, therefore only the company will be restricted.
They will hear you. Yes, Mr. Purmi.
My lord, in the charge sheet of CBI found nothing against the company. Company was not made an accused person. We cannot go beyond that. Matter ends there. We cannot drag the company indirectly or by creating a relationship or something like that. It is not accused person, it is not accused person, and the matter ends there. Now, my lord, coming to the question number 82, relied upon, or circular, relied upon by my sister, it talks about under 278B of the Income Tax Act, not the Prevention of Corruption Act. So it is 278B, there is no proceeding against the company or even the directors. I will not go to the director, I would say, against the company. There is no proceeding under the Income Tax Act. If that had been so, then I would have excluded under the 9C on that ground. This is one thing, my lord. And second thing, judgment relied by my sister, my lord, kindly see the last page. Last page of judgment of Tanna and Modi. The conclusion.
Yes.
Seventh row from the top, my lord. Seventh row from the top.
Yes.
A firm is the conglomeration of its partner. A firm is a conglomeration of its partner, is not a juristic person. So the firm and its partner are not two, they are one. So if there is a prosecution against the partner, it is a prosecution against the firm and the vice versa. But it is not true in case of a company. Judgment I have relied upon, my lord. Supreme Court judgment I have relied upon, and now my lord, it is fairly well settled. The shareholders, the directors, and the company, they are three different entities, and they are three different juristic person. For the purpose of income tax, the firm and its partners, my lord, just I am harping on particular point. For the purpose of assessment, the company and a partner for a limited purpose are treated as separate entity. But as far as coming to the juristic person is concerned, they are not separate juristic person. It is one thing to say that the partnership firm and the partners are different entities.
Yes.
But juristic, when it comes to juristic person, they are one same. That's what the court says. But the same principle will not apply to a company. When it comes to company definitely has a separate juristic entity. So unless a prosecution is launched against the company or prosecution is instituted against the company, 9C cannot be pressed into service. My lord, identical issue was there before Supreme Court under the Kar Vivad Samadhan scheme. Identical almost. That is, my lord, in my compilation. Kindly see, my lord, page 56. Shashi Bal Subramanian, my lord.
Yes.
Now, my lord, kindly keep page 21 side by side, section 9C9, because my learned sister is also relying on the word person. 9C talks about a person, and person is not defined in the act, but section 2, subsection 2. Section 2, subsection 2 reads, just I am reading it down, my lord. The words and expressions used herein and not defined but defined in the Income Tax Act shall have the meaning respectively assigned to them in that act. Section 231 of the Income Tax Act, 2 subsection 31 of the Income Tax Act deals with the definition of person. If you lordship have got the Income Tax Act, my lord, kindly have a glimpse of it. Section 2, subsection 31.
Yes.
9C talks about a person against whom. So whether this person is different from the declarant, that is the point. If the person and declarant is what is same, then the prosecution must have been issued against the declarant himself. That is the point, my lord. I am addressing that point now. Person includes, my lord, person includes Income Tax Act, section 2, section 31. Person includes an individual, a Hindu unwed family, a company, a firm, an association of persons, or a body of individuals, whether incorporated or not, a local authority, and every artificial juridical person not falling within any of the preceding subclauses. For the purpose of this clause, an association of persons or a body of individual or a local authority or an artificial juridical person shall be deemed to a person whether or not such person or body or authority or juridical person was formed or established or incorporated with the object of deriving income, profits, or gains. So, I would assume that the meaning of person is borrowed from the Income Tax Act into this act. Then where do we stand, my lord? Whether 9C is going against me in any way? 9C says, my lord, the provisions of this act shall not apply to any person in respect of whom prosecution for any offence punishable under the provisions of the so and so act has been instituted on or before the filing of declaration, or such person has been convicted of any such offence punishable under any of those acts. So the person here means the person who is filing declaration, the declarant. And declarant is defined, my lord, in under section 2, subsection, kindly see, my lord, section 2, subsection C, page 17.
Yes.
Declarant means a person. Again, the word person. Person to declarant, declared to person. Declarant means a person who files declares under section 4. Then, my lord, kindly see. Kindly see his judgment, my lord. Page 56.
It's
The remaining portions are, my lord, on page 58.
yes.
Under similar situations or some for same purposes with the same objective, the Kar Vivad Samadhan scheme was launched in 1998, and those provisions of that act is quoted below. And the similar interpretation issue came before Supreme Court, whether the person would be declarant.
Yes.
Wherever the legislature used the word person, would it mean declarant? That was issue, my lord. Kindly see page 16, page 58, my lord, para 68.
Yes.
Declarant has been defined, section 87A, to mean a person making a declaration under section 88. Disputed tax has been defined in section 87 F to mean the total amount, total tax determined and payable in respect of an assessment year under any direct tax enactment, but which remains unpaid as on the date of making the declaration under section 88. Indirect tax enactment has been defined under section 87J in the following terms. I am skipping, my lord. Para 17. Section 87K of the Act defines the person to mean K. Person includes an individual, a Hindu undivided family, a company, a firm, an association of person, or a body of individual, whether incorporated or not, a local authority, every artificial juridical person not falling within any of the proceedings of clauses. Then there is addendum. This is copy of the Income Tax Act 231. Then there is addendum specific to this act. SSA as defined in Rule 2 of the Central Excise Rules to 1944. Exporter as defined in 230 to 20 of the Section 2 of the Customs Act. Importer as defined in Clause 26 of Section 2 of the Customs Act. Any person against whom proceedings have been initiated or and are pending under any direct tax enactment or indirect tax enactment. Then, my lord, 88. Section 88 internally provides, subject to the provisions of the scheme, any person makes on or after the first day of 1998, but on or before 31st day of 1998, a declaration to the designated authority in the accordance with the provisions of Section 89 in respect of tax area, then notwithstanding any the contained in the direct tax enactment or indirect tax enactment or any other provisions of law for the time being in force, the amount payable under this scheme by the declarant shall be determined at the rate specified herein, namely. Then I am skipping this portion, my lord, that was specific to that particular act. Para 18, my lord. The declaration is required to be filed in the form prescribed. Therefore, time and manner of payment of tax area is provided in Section 90. Section 91 provides for immunity from prosecution and imposition of penalty in certain cases. Section 95 provides the exceptions as regards the applicability of scheme. Clause 3, whereof, which is relevant for our purpose, reads as under Section 95. The provisions of this section shall not apply. 3. To any person in respect of whom prosecution for any offence punishable under Chapter 9, Chapter 17 of the Indian Penal Code, the Foreign Exchange Regulation Act 1973, the Narcotics, Drugs and Psychotropic Substances Act 1985, the Terrorist and Deceptive Activities Prevention Act 1987, the Prevention of Corruption Act 1988, or for the purposes of enforcement of a civil liability has been instituted on or before the filing of declaration, or such person has been convicted of any such offence punishable under any of such enactment. The principal question which arises for consideration are whether the scheme is applicable in relation to public servant, when does the prosecution start, whether the offences enumerated under section 95(3) are excluded from immunity in terms section 91 of the Act. Then, my lord, just I'm skipping part 22. Section 2K11, which defines a person, undoubtedly addresses within its fold those against whom proceedings have been initiated, but the same relate to direct or indirect enactment. Proceedings contemplated under the Act must have a nexus with areas of tax. Public servants who can never file a declaration would not, in our considered view, come within the purview thereof. 23. Of course, there exists a distinction between a person and declarant. However, declaration is to be filed by the person who would come within the purview of the said term, as has been stated in the interpretation clause contained in section 2K of the Act. Section 88 provides for declaration to be filed made by a person, and the declarant means a person making a declaration. The applicability of provisions of the Act must be judged in the aforesaid context. 24. The definition of person must be read having regard to the term declarant, that is, who files a declaration. So, my lord, my submission is that the word person and declarant is one and same. Declarant files a declaration, he is a declarant, and the person against whom prosecution must have been instituted is a declarant only. The word person cannot be read divorced of the word declarant. The word person has to be read in the context of declarant. That's what the court held in that act. Then, my lord, straight away kindly come to page para 25, my lord. In that case, there was issue whether public servant can file declaration or not. The court was addressing that, and the court said the person must be declarant against whom there is tax area. Because against the public officer, there is no tax area, he cannot be a declarant. That's what the court was dealing with. Paragraph 25. A public servant is enjoined with the duty to enforce tax enactment. A declaration in terms of section 88 can be filed by a declarant for determination of a tax area under the scheme at the rates specified thereunder. Public servant, therefore, cannot take the benefit of the scheme. Section 90 provides for the time and manner of payment of tax area. The amount of tax, area of tax, is required to be determined within a period of 60 days from the date of receipt of the declaration under section 91, whereupon a certificate is to be granted in such form as may be prescribed. The certificate is granted only to a declarant, which would contain the particulars of tax areas and the sum payable after such determination towards full and final settlement of the areas. Then, my lord, kindly come to para 29 straight away at the bottom.
Yes.
It is in this aforementioned context, interpretation of the word prosecution assumes significance. The term prosecution would include institution or commencement of a criminal proceeding. It may include also an inquiry or investigation. The term prosecution and provenance are not interchangeable. They carry different meaning. Different statutes provide for grant of sanction at different stages. Paragraph 31. The term prosecution has been instituted would not mean that charge sheet has been filed and cognizance has been taken. It must be given its ordinary meaning. The legislature, with a definite purpose, thought of granting an exemption from the operation of the Act if no prosecution is instituted under the provisions of the statute specified thereunder. Chapter 9 of the Indian Penal Code deals with public servant. Chapter 17 thereof deals with offences relating to property. Offences under other enactment are of serious nature. Thus, presumably, commission of offences under the Act enumerated therein were considered to be serious enough by the Parliament so as to exclude the application of the scheme, which includes Prevention of Corruption Act. Then, my lord, para 35. The reliance placed by Mr. Singhvi on Diparapalli
No, whether the question which is posed in your case, that because of the initiation of prosecution against your director, your declaration is liable to be rejected. That answer flows out of this judgment which you are reading specifically.
Yes, my lord. Para 23, 22, 23, 24.
That we have seen that there is a difference between the expression person and a declarant.
But 24 kindly see, my lord.
Yes.
Person has to be read in the context of the word declarant. So it cannot read the type host of declarant. So the 9C will apply to the person who is a declarant. The 9C will apply to a person who is a declarant. In this case, the director is not declarant. If a director files a petition, then he will be excluded, but not the company. Separate legal entity as a juristic person of the company is not in doubt. The judgment in the case of Tannan Modi was in respect of partnership firm. Partnership firm is not held, is not to be juristic person, but the company is. And in the charge sheet, the company is not prosecuted or company is not made accused person. So, my lord, that is in the counter affidavit.
We have placed the entire charge sheet in the rejoinder also. The entire, they have placed only some part of the charge sheet. We have annexed the entire charge sheet.
That is, my lord, rejoinder. Kindly see page 13. Page 13 of rejoinder, my lord.
Just.
Page 13 of the rejoinder, my lord.
Yes.
Last but one para, my lord, as per the list of documents.
Yes.
Last but one para, as per the list of documents and list of articles attached, particulars of accused persons charge sheeted. A1, accused person 1, name is there, my lord.
Yes.
Then, my lord, kindly see next page, last para, A2.
A2. He is the director. A1 is the director.
The director is at page, my lord.
Page 20.
He was the.
Page 20, A10, my lord. Bottom, my lord.
Sunil Kumar Shah. Sunil Shah.
Yes, my lord.
Page 21 also, sir, kindly show.
Yes, my lord. 21 count by seen under Act sections 120B IPC, read with 7, 8, 12, 13, 2, 13, 1, 3D of PC Act. IPC and PC Act, my lord. Then other accused are there, my lord, thereafter. And what's
Name
the
of the
cognizance, my lord?
material, no, material alleged as against A10.
My lord. That is on page, my lord. Kindly see 33, my lord.
Controller of the company, Sri Sunil Shah.
Sixteen point 18.10.
Yes.
Under cognizance, you may see page 61. Your lordship may straight away come to page 65.
Yes.
65 is relevant, my lord. On considering the above discussed facts, page 65, second para from top. My lord, second para from top.
Yes.
Order of cognizance, my lord. On considering the above discussed facts supported with oral and documentary evidences collected by investigation agency, I find there is sufficient material available on the record to constitute a prima facie case under section 120B IPC so and so against the accused person so and so to proceed in this case as sanction for prosecution against the accused issued by competent authorities available on record. Further, there are materials for commission of offence punishable under 120B IPC and section 78 so and so of the Prevention Corruption Act against the accused person, namely all names are there, my lord. And kindly see the highlighted portion at the bottom. Accordingly, I took cognizance. Accordingly, I took cognizance of the offence under 120P IPC, section 7, 11, 13, read with PC Act against accused. The names are there. The director's name in the third line from the bottom, my lord.
Yes.
Seal number 10. So the cognizance is also taken against the director.
Yes.
Company is nowhere, neither in the charge sheet nor in the order of cognizance. Company
इसलिए हर कंपनी का ये हुआ है कंपनी का There are a few more points, Mr. Purni, perhaps which you would like to develop.
My lord. My lord, one judgment I would like to show you, Lordship. Tanha and Modi, led by my learned sister, where I have shown you, Lordship, the Supreme Court has held that a partnership firm is not a juristic person. On the contrary, my lord, in respect of company, Supreme Court has held that a company is a juristic person. That kindly see, my lord, page 68 of the compilation judgment starts. Page 68 of the compilation judgment starts. Kapila Hingorani. Page 68, it starts, my lord, and the relevant portions are on page 84.
The juristic person concept we understand. Here the issue is whether the juristic person gets bind by the illegal acts of its directors and he becomes disentitled or ineligible to avail of this kind of a beneficial legislation.
Yes, my lord. Yes.
In the present case, the prosecution is not in connection with any IT Act offences.
Correct, my lord.
Now, there are statutes which make the directors liable for offences by the company by way of vicarious liability, like the Negotiable Instrument Act or maybe some other acts also, Companies Act also might be there. But the other way around, that some illegal acts of the director or employee managing the affairs of the company makes the company also liable or disentitled by virtue of that kind of a reverse liability. Is there any proposition to that effect?
My lord, vicarious liability is concerned, it is one way only, not the other way. And also, my lord, I would submit, if I subject to correction, my lord, I may be totally wrong. In criminal law jurisprudence, vicarious liability concept is not there.
Except where the statute defines.
Unless the statute clearly speaks about that.
Special acts.
Special act. Now, my lord, if we confine my submission to 9C itself only, I don't look here and there, then it is very clear the provision of this act shall not apply to any person in respect of whom prosecution of any offence has been instituted. Now, who is a person? Section 231 of the Income Tax Act says, director is a person, company is a person. So now, and the word declarant. So declarant and person will become declarant only when he is eligible. So the word person cannot be read diverse of the declarant. A person cannot become a declarant unless he meets the exclusion clauses, he is out of the exclusion clauses of 9C. If he is out of that, then he will become declarant and he can file a declaration. He will get the immunity from payment of interest and penalty and prosecution and all that.
Yes.
So, my lord, this word 9, here we concentrate ourselves only on the language employed by the statute, then things are very clear. And Supreme Court in the Malasubramanian case was dealing with the identical words in which the word person and declarant, these two words were used. And in the context of, under the clauses which dealt with exclusion, there also, there was a provision for exclusion. And in that provision also, the word person was used. Then the issue came for the court whether this person would be declarant or not. The court held that the word person has to read in the context of the word declarant. So the scheme of the act is declarant centric. Person qualifies or disqualifies. The person qualifies as a declarant, and the person cannot become a declarant if he is disqualified.
Yes.
That's what 9C says. Any person can file, but he will be eligible only if he comes within the meaning of the word declarant. So, my lord, kindly say. My written notes of argument, my lord, kindly see. Page 2, my lord, propositions. One, the provision of Direct Tax Viswas Act 2020 is declarant centric. Person under section 9C has to be read in the context of declarant under 2C. The law, in law, company and its director are separate legal entities. Section 9C cannot be invoked if prosecution is instituted against the declarant. Can be invoked if prosecution is instituted against the declarant, that is the petitioner company herein only, not its director or any other person. Then second, my lord, Direct Tax Viswas Act 2020 is a beneficial legislation. Section 9 is exclusion clause. Exclusion clauses of a beneficial legislation must be strictly construed and its benefit must be liberally extended, applying the purposive construction. My lord, on this I will rely on judgment of Supreme Court in the case of Pappu Sweets, page 170, my lord. Page 170, my lord. And the relevant portions, my lord. The relevant portions are on page 173. Para 10, my lord.
Page 173.
Page 173, my lord. Judgment starts on page 170, my lord. Judgment starts on page 170. We are concerned with page 173, para 10. Third para from the top, my lord.
Yes.
Page 173, my lord. In the compilation.
Yes.
Para 10, my lord. The notification under further discloses that the object of declaring exemption from payment of sales tax was to increase industrial activity in the state by encouraging setting up of new industrial units or expansion, diversification, modernization by the existing industrial units. At the same time, the state did not desire to extend the benefit to all such industries. It was therefore specifically stated in the notification that industries mentioned in Annexure 2 shall not be entitled to the benefit or exemption from payment of tax or reduction in the rate of tax. Presumably, the state did not desire further growth of such industries by suffering loss of revenue. Now, these lines are important, my lord. What is, however, necessary to note is that Annexure 2 is an exclusionary part of the exemption notification. The High Court did not examine the issue from this angle and also failed to appreciate that exclusively part of an exemption notification has to be construed rather strictly. Now I'll pause for a while. I would say in the exclusion part of a notification or an statute, if something is mentioned, it should be strictly construed. If one is following in the strict letter of law only they can be excluded because the scheme of the act or the legislation is a beneficial one. The purpose is to extend the benefit. Certain persons are excluded. So the list in the list of exclusion persons excluded, if one falls strictly, then all he should be excluded. He cannot be excluded by analogy or by implication or by presuming certain things. Has to be construed rather strictly.
Yes.
Even though the word used in the exclusionary part of an exemption notification has a wide dictionary meaning or connotation, only that meaning should be given to it, which would achieve rather than frustrate the object of granting exemption and which does not lead to uncertainty or unintended results. So, my lord, the word person under 9C is only declarant. If it is not declarant, if it is held it is not declarant, then it would mean that the exclusionary part are being read widely, not strictly.
So just to supplement here, if it is not read as declarant, then even shareholders prosecuted will come into it.
Then, my lord, kindly see page 175.
Yes.
Page 175, my lord. Judgment of Supreme Court in Government of Kerala versus Mother Superior. The relevant portion, my lord, is on page 196.
This is what I was going to say, that the judgment which you are citing about interpretation of exclusionary clauses,
My lord.
perhaps has also been referred to in this latest judgment.
My lord.
That the previous judgment has perhaps also been referred to. There's a different line of reasoning which has been taken up in this Kerala judgment. Perhaps Mr. Garodia had earlier cited this.
Yes, my lord, I cited it earlier, my lord, in polycab matter, my lord. One matter I cited.
So Pappu Sweets has been referred to in this judgment.
Pardon, my lord?
That Pappu Sweets judgment has also been referred to in this judgment, or not?
That I have not seen, my lord.
The list of citations you can find.
Yes, it is on page 180, my lord.
It is 2004.
I don't see it, my lord.
It's not.
My lord, page 196.
Yes.
Para 27, my lord.
Yes.
This being the case, it is obvious that the beneficial purpose of the exemption contained in section 3(1)(b) must be given full effect to the line of authority being applicable to the facts of the case, these cases being the line of authority which deals with beneficial exemption as opposed to exemption generally in tax statutes. This being the case, a literal formalistic interpretation of the statute at hand is to be eschewed. We must first ask ourselves what is the object sought to be achieved by the provision and construe the statute in accord with such object. And on the presumption that if any ambiguity arises in such construction, such ambiguity must be in favor of what is of that which is exempted. Consequently, for the reason given by us, we agree with the conclusions reached by the impugned judgment of division bench and the full bench. So then kindly see, my lord. Page 153.
We will continue on any other day. No.
My lord, just one judgment I am reading and concluding, my lord, because it is on same line, beneficial and exclusion. This judgment I am reading and I am concluding, my lord, today.
Yes.
Page 153, my lord.
153. This M. Nizamuddin.
Nizamuddin. The relevant portions are, my lord, on page 168.
Your written
Para
submission.
38, my lord. Page 168, para 38.
Para 68.
38, my lord. Page 168.
Okay. Yes. Yes.
It's well settled that if exception has been added to remedy the mischief or defect, it should be so construed that it remedies the mischief and not in a manner which frustrates the very purpose. Purposive construction has often been employed to avoid a lacuna and to suppress the mischief and advance the remedy. It is again a settled rule that if the language used is capable of being more than one construction, and if the construction is implied that results in absurdity or anomaly, such construction has to be rejected and preferences should be given to such a construction that brings it into harmony with the purpose and avoids absurdity or anomaly, as it may always be presumed that while employing a particular language in the provision, absurdity or anomaly was never intended. For the anomaly between the word person and the word declarant, the legislature never intended to create this anomaly between these two words.
Right. So the gist of your submission is that in case the prosecution of a director, or rather the other way, if the declarant is not the person against whom a prosecution is launched, then he is entitled to get the benefit of this scheme.
Yes, ma'am. That is what 9C exactly says.
Very good. The declarations, what was the cutoff date for making these declarations?
My lord, kindly see the compilation. Cut-off dates where in fact it was extended. So kindly see the comparison, my lord. That is page.
It was extended to 31st of March 21.
21.
21, yes, Your Lordship.
Page 27, your lordship may see. It was extended twice, my lord. Rather, I would say thrice.
Yes.
My declarations were filed prior to that, my lord.
That is not in this. So we will hear it on another day, the respondents?
Yes, Your Lordship.
My lord, if it suits your calendar, your lordship, may I pray for 9th?
Next week, perhaps we have already a very
Any virtual day, my lord.
So now it will be virtual.
agreed. Very well on 9th. Let us see if we can.
9th, Your
Oblige, my
Lordship.
lord.
I have a matter fixed before the other division bench, Your Lordship. It might take longer time in that matter also.
That individual accommodation in the morning or in the later part of the day, that always happens. Here, then, counsel for the petitioner, Mr. Karthik Kurmi, has advanced his submissions for reply on behalf of the respondents. Let the matter appear on 9th August 2020.
Deeply obliged, my lord.
Yes. Now,
Obliged, Your Lordship.
I feel hearing between two sides.
शीशा शीशा का जगह जो है छोटा है
Who is appearing in item 15?
Milords, I am appearing for the petitioner in this matter, Milords.
My lords, for the state, I am appearing, my lords.
Last week an adjournment was taken by the state perhaps.
Yes, my lords.
Their supplementary counter was not on record, hence the matter was adjourned.
Oh yes.
Now, it's only one submission I had to make if my learned sister agrees that the judgment of this honorable court in MCAS and the judgment delivered today is directly applicable. Then, Milords, I will not be arguing much. And if she does not agree, then in that event, I'll be placing my case properly.
We'll take up after lunch.
Yes, Milords.
Much obliged, my lords.
I have a tied up bench, so let's see if we can continue with that, and then maybe after an hour or so.
As night, please.
Obliged, my lords.
Very good.